Good evening, Mayor and Council. My name is Joan Chambers. My office address is 2210 Northeast 22nd Street. I'm an attorney here in town, and I'm appearing to testify on behalf of our client, Lincoln City Tourism Alliance, LLC, which is an aggrieved party. I've brought some written submittals. I will provide these for the council before I leave, but I'll just try and summarize some of the points I think are more important. There's provisions in here that deal with the zoning ordinance criteria for a textual amendment of the zoning ordinance. In one of the requirements in section 17.88.050 sub D, the council must make findings of facts. It must be found that the amendment complies with and conforms to the comprehensive plan goals, policies, and land use map. It may be further necessary to provide evidence that the proposed amendment is in conformance with statewide land use planning goals and policies when a more specific direction is provided by the goals in the comp plan. Normally, the burden of proof would be on the applicant. There's no citizen applicant submitting these changes. This is brought up by the City Council. So you need to find evidence in the record. And so far, I haven't heard much evidence in support of these proposed amendments. The comprehensive plan in subsection G of the goal that reads plan goals, policies, implementation strategies, forecasts, and distribution and allocation formulas as a review and amendment, and then zoning ordinance text amendment. There are 5 different criteria that the council needs to be making findings on, and there are alternatives. And again, I've got that set forth, and you should be looking at those issues. The city has not considered or addressed procedural provisions of the comp plan, and the findings must be supported by substantial evidence submitted into the record, and it requires that the amendment complies and conforms with the comprehensive plan goals, policies, and land use maps, and it can also require that the city consider city comprehensive plan goals related to and some of those goals that haven't been considered, excuse me, I'm losing my voice, but is the Citizens Involvement Program and the economy goal. The city established a VRD consensus project staffed by a neutral convener and consisting of 20 or more citizens and affected parties in Lincoln City. The committee came up with the well-reasoned recommendations, which the City Council has ignored, and is now proposing to adopt ordinances that are not consistent with the recommendations of the citizens. Thank you. Excuse me. And affected individuals who made recommendations in the consensus project final report. In rejecting the report, the City Council is failing to give appropriate consideration to Goal 1 of the city and statewide planning goals. Similarly, the city has not reviewed the effect the proposed ordinance would have on the local economy or economic development. The city obtains more than $500,000 a year in transfer room tax from the vacation rental dwellings. That money helps support the general fund and the police department. Besides the possible negative budget effects that could result, the city has not considered the money that the visitors staying in vacation rental homes spend in our community. And I think Mr. Oxenholt testified about the multiplier effect from an economic standpoint, and I would just concur that he's right on those issues. I would also comment on the city attorney who had 20 to 30 minutes to talk about issues at the start of the meeting, where he talked about, and I believe the city manager has talked about this issue as well, that the vacation rental dwellings could have an impact on the residential dwelling number of single-family dwellings in the city for purposes of the state goals. The city's definition, in the case of Yogman versus Parrott, which is a case that arose in Lincoln County before Judge Littlehales, when he was still a judge, the judge was asked to interpret a provision in CC&Rs that said all lots within said tract shall be used exclusively for residential purposes and no commercial enterprise shall be construed or permitted on any of said real property. The Yardmans used their beach house as a vacation home when they were not using it, or used it as a vacation home rental when they were not using it themselves. They rented it out for short periods of time. On appeal, the Oregon Supreme Court went through the analytical interpretive steps regarding the wording of the covenant. The court also differentiated between the Yardmans renting their vacation home and a business organization, which they defined as a bed and breakfast business, which had profit as a primary aim. Ultimately, the court determined that the rental of the home did not violate the restrictive covenant, and it was not considered a commercial use. Again, that's a case out of Lincoln County, decided ultimately on appeal to the Oregon Supreme Court. I have a number of other things here. One thing I would like to comment about, there's a perception that VRDs create enforcement problems from city staff and the police department. Again, at the consensus committee meetings, Chief of Police Stephen Beckard and Timothy Novak, the city's designated VRD enforcement officer, told the group that VRDs are not responsible for the creation of much police activity. They simply don't have as much of a problem. I will conclude and leave my materials with
the clerk. That'd be great. Thank you very